Hello and welcome back to this series of lessons on legal reasoning for the CLAT. This is lesson number 2, and if you have been watched lesson number 1, I would advise you to go and watch that video. It will make better sense if you watch that one before you watch this one. But that's up to you anyways, ladies and gentlemen. And in this lesson, we will look at the 3 types of legal reasoning passages that one could encounter in the CLAT legal reasoning section. Now, the last lesson, I talked about these 5 critical things when it comes to legal reasoning. Number 1 being the issue. What is that we are trying to solve? What is the problem we are trying to solve in terms of coming out with an answer to a question? Like whether some person is liable or some person is guilty. What is a specific issue under discussion? To arrive at that, we need to have certain rules. Rules are principle that is given in the passage or maybe in the question itself to arrive at the conclusion, and then we need to have facts, those things that are relevant and those relevant things that we can apply to the rule, and then at the conclusion the process of analysis is applying to the facts onto the rule, and then we come with an outcome. What I also said that when it comes to the current version of legal reasoning questions where you get passages or a passage and then you have got 5 questions for that follows that particular passage. The passage is the place where you get the rule. But is that so? Are there different types of legal reasoning passages in terms of where you find the rules or where you find these facts? Facts are usually found in the question, but is it also possible to find the facts in the passage itself? Or how are these rules even presented to us? These creates a different types of legal reasoning passages. But by and large, you see the structure of the questions are the same. You get a passage followed by those 5 questions, and let's look at the 3 different types of passages, ladies and gentlemen. Let's start with the first one, where the passage gives you rules. That's it. This is something that we normally find in the legal reasoning passages. If you look at the CLAT 2020 paper or all the sample paper that they released last year, you will find the passage is the place where they get the rules. And here is one such passage from CLAT 2020, questions 81 to 85. There's a passage. So let's look at the rules. So what I told you even in the last lesson is that when I read this passage, what I want to understand is what are the rules. And I talked about the fact that it's like a traffic signal, the red signal, which actually gives me the rules. And there are these yellow signals, which words or sentences which indicates that this is probably an important part. And then there are those sentences which are merely green signal, which I would say that I will just go past. I will obviously read it, but I will not commit to my memory. But I really want to understand what the rules are. That is a skill set that we need to develop. So let's read this passage here. It's got 2 paragraphs. Let's see paragraph number 1 and understand what is given in paragraph number 1. Let's start reading it. The principle of natural justice is derived from the word jus natural of the Roman law, and it is closely related to common law and moral principles, but is not codified. The first sentence, important thing is we can understand what the discussion is. The discussion, ladies and gentlemen, is about the principle of natural justice. Wonderful. And it's saying that, and the next part is the detail of it, right? This part is giving certain detail of this, saying that what is principle of natural justice, the fact that it's not codified, it is related to common law, it is moral principles. But what we need to understand for sentence number 1 is the fact that the discussion is going to be about principles of natural justice. Wonderful. It is a law of nature which is not derived from any statute or constitution. Another piece of detail. So this is another, I'm putting it this green color because this is a piece of detail. This is actually not giving us any rules. It's just merely describing this principle of natural justice. It's not derived from any statute or constitution. It's very similar to suggesting that it's not codified. It is not derived from any statute or constitution. Okay, let's read on. The principle of natural justice is adhered to by all citizens of civilized state with supreme importance. Another piece of detail. It is adhered by everyone. Perfect. Natural justice simply means to make a sensible and reasonable decision making a procedure on a particular issue. So now you get some certain little more important detail. It says it's making a sensible and reasonable decision. The moment you have words like sensible and reasonable, it's very difficult to ascertain what is sensible and what is reasonable. And obviously in the law there is this reasonability test, which is based on what a reasonable person would do or what a sensible person would do. So it's about making sensible or reasonable decisions. That's what natural justice is all about. Okay, let's carry on. Sometimes it doesn't matter what is the reasonable decision. Oh, but in the end, what matters the procedure. What matters procedure and who all are engaged in these reasonable decisions. So the another critical aspect it's not about the reasonability itself. It's more in terms of procedure or how someone has arrived at a decision. How the procedure is what is important. So all that we understand from paragraph number 1 so far is a discussion, ladies and gentlemen, is about natural justice. Let's call it NJ, and the fact that here it is procedure is what is critical, and then to arriving at a reasonable decision. The reason why I understood this to be my red signal, ladies and gentlemen, is that when we look at a legal reasoning passage, I need to make decisions at the end. In the sense, I want to answer a particular question which poses me a situation, an issue, and say that make a decision on this. Tell me whether it's yes or no. For me to make a decision, I'm looking at words which or sentences which gives me some direction to make the decision. Now this particular thing is a good direction, saying that I'm interested in the procedure. Procedure is important, and that's a good direction. Therefore, that is my red signal. For example, this particular thing, the fact that it's not derived from any statute or constitution, is not giving me any source to make a decision, right? It's not a decision criteria sentence. It's merely explaining something. So this particular part is explaining it, or further, it's merely explaining what natural justice is. This is actually giving me some path to make a decision. So which is why that to me is a red signal. I hope I'm making sense here. Okay. It is not restricted within the concept of fairness. It is different from colors and shades which vary from context. Basically, natural justice considers 3 rules. And now this is all important. So all that is saying here that natural justice has got 3 rules. And therefore, at this point in time, all I've gathered from paragraph number 1 is that natural justice is focused on procedure to arrive at a reasonable decision, and there are 3 rules. That's it. So there's nothing much that I can derive from paragraph number 1 in terms of my red signals. My red signals are those things, but red sentence or red words are those things which helps me eventually to make a decision on a question that is going to be posed to me. This is not a reading comprehension passage. Reading comprehension, probably other things also is critically important, but here legal reasoning, I have to eventually come out with a reason, arrive at a decision. So I need to understand this red signal, ladies and gentlemen. So I'm interested in 3 rules. All that I'm going to do, therefore, in the next paragraph is to look at what are those 3 rules. So I'm going to look at 1, 2, and 3. Let me pick 1, 2, and 3 and see. Okay, let's understand what are the 3 rules. The first rule is hearing rule. We have got, ladies and gentlemen, the first rule, which is hearing rule. So let's look at HR. I'm going to call it HR hearing rule, which says the person or a party who is affected by the decision made by panel or of experts should be given a fair opportunity to express his point of view, to defend himself. So people have to be given opportunity. So he's saying that people have to actually given opportunity or a fair opportunity to express their position. Okay, if that does not happen, then you've broken natural justice. And then you have the next one, ladies and gentlemen, which is the bias rule. Also, there should not be any bias, right? So that's what that would say. Generally expressed that the panel of experts should be free from bias. So that's what it said. The panel of experts should be free from bias while taking the decision. So there's no bias with the expert who's making the decision. The person making the decision should not have any bias. Perfect. The decision should be given in a free and fair manner which can fulfill the rule of natural justice. And thirdly, ladies and gentlemen, we have the third one, which is reasoned decision. So there are third rule, which is reasoned decision. I'm going to call it RD, which states that the order, decision or judgment of the court given by the presiding authority with a valid and a reasonable ground. There has to be some reasonable or valid ground. So there has to be a reasonable and valid ground for this, which means you have to give certain explanation, a reasoned explanation as to why to come to that particular decision. You can't give it something arbitrary. The principle of natural justice has been adopted and followed by the judiciary to protect public rights against arbitrary decision by the administrative authority. One can easily see that the rule of natural justice include the concept of fairness. They stay alive and support to safeguard the fair dealing. So when we read this particular passage, ladies and gentlemen, this is all that I take away. So for me, when I read this passage, what I understand is that the passage talks about natural justice in the fact that there are 3 rules. Rule number 1 is a hearing rule. Rule number 2, there is a bias rule. Rule number 3, there is a recent decision rule. The hearing rule, you have to be given fair opportunity. Bias rule, no bias. Recent decision, the decision has to have certain grounds. That's it. So your ability to do legal reasoning pretty well and also pretty quickly, which is something that I'll do in the next lesson in terms of how fast we can solve these questions, how to manage time in legal reasoning, which will be lesson number 3. But you the more you practice, or when you practice legal reasoning questions, you must be able to identify rules. And that is a skill set that you need to develop. If you develop the skills, ladies and gentlemen, things should be fine. Now, once we understand this, let's have a go at the questions. Nemo iudex in causa sua, or the principle that no one can be a judge in his own cause, relates which of the following. So no one, for my own cause, I cannot be a judge. I cannot be hearing my own cases. Ladies and gentlemen, that would be basically biasness, right? Which a rule is a bias rule. It is not this is not a reasoned decision rule, nor it is a hearing rule. Therefore, it's not all of the above. It's biasness. So you should avoid biasness, which is what it is. Panel should be free from bias while taking the decision. So if I am the judge of my own case, then there is biasness that is going to crap. Did I use the word crap? Did I use the word crap? I don't know why I used the word crap. I don't know what word I was supposed to use. Ladies and gentlemen, I'm carrying on. It's not a recent decision. Recent decision talks about something else, and hearing rule talks of something else. Then you have answer choice to that question. Question number 82. Let's give it a go. Mr. X is a public servant employed in a PSU, and Mrs. Y, who is a wife of Mr. X, is also employed an employee of the same PSU. Miss A files a complaint against Mr. X for sexual harassment at workplace before the ICC Internal Complaints Committee, which is headed by Mrs. Y. After completing her inquiry, she held that Mr. X is guilty and recommended disciplinary proceedings against him. Now, at what grounds? So the issue is, what grounds Mr. X may challenge her findings. So Mr. X has said that Mrs. Y, you cannot do this. So there is a Mr. X and you have got a Mrs. Y. They are married, and there is a charge by Miss A against Mr. X, and for that Y has given the ruling. So out of the 3 rules, ladies and gentlemen, we have got hearing rule, bias rule, and then recent decision. So what ground? The best thing that Mr. X can do is biasness. His wife, who knows? Maybe at home they're not having a good relationship. Who knows? The question is merely asking at what grounds that Mr. X may challenge the finding. Challenging of the findings is about this biasness rule, right? The panel should be free from any bias while taking the decision. Therefore, we are looking at answer choice. I'm sure that there is an answer choice which speaks to you. Bias, I can see that in answer choice number C. Mrs. Y is the wife of Mr. X, and she holds a personal bias in this case, so the inquiry should not have been conducted by her. That makes a lot of sense, right? That makes a lot of sense. A. Mrs. Y is an employee of the same institution, and the inquiry should be conducted by a person outside the institution. But what is this? Which rule? The complaint was filed by a female employee, so the inquiry must have conducted by male. What is this? Okay, Mr. X being the accused should be conducted the inquiry himself. Amazing. I think that ditch me. That's an easy ditch me, right? So you can easily ditch me, absolutely ditch me. Okay, if you actually answer choice number D as the right answer choice, if for someone who marked answer choice number D, ladies and gentlemen, the author will commit suicide. Whoever wrote the passage will commit suicide. How can he mark D? Answer choice in this case is very clearly C, my dear fellows. 83. Mr. A is a judge and is also the landlord of Mr. B, who resides in an apartment owned by Mr. A. Due to the non-payment of rent for 3 consecutive months, Mr. A served an eviction notice to Mr. B. Now choose the most appropriate option amongst the following. So we have 3 rules: hearing rule, bias rule, and recent decision. Okay, let's talk about hearing rule. This is an eviction notice. Eviction notice would mean that you have to evict for a certain period. If you don't pay me the money after a certain period of time, you will have to leave. Eviction notice is not saying that get out of my house. It is giving a notice that I'm going to evict you. So now you have a chance to respond. So there is no problem with hearing rule. Hearing rule is satisfied. It is given hearing rule, no problem. Okay. Biasness. Okay, now you would say judge. But he's a landlord. And landlord can give eviction notice. Who else will give eviction notice? The landlord has to give eviction notice. So it's fine. So where is the biasness here? There's no biasness, ladies and gentlemen. Check. There is no biasness. So biasness rule, no biasness. I think hearing rule, no problem. Recent decision. So reason is fine. He has not paid rent for 3 consecutive months. There's no problem. So there is fairness. There is fairness. There's no problem. So the fact that they cannot issue notice, no. Mr. X can issue such a notice because it is his duty as a judge. No. He is not issuing his notice as a judge. He is issuing the notice as a landlord. Such notice is illegal. Why? Answer choice is D. Mr. A issued such a notice in his personal capacity as a landlord and not being a judge, which makes a lot of sense. Eviction notice, right? Eviction notice. That's what a landlord actually gives. Answer choice D, ladies and gentlemen. Question number 84. Which of the following is not in violation of the principles of natural justice? Okay, so we are looking at something that is not in violation of the principles of natural justice. Okay, so we should not violate HR, should not violate BR, should not violate RD. Ladies and gentlemen, let's look at question number 1. Withholding an increment of a public servant without giving him an opportunity to defend. My goodness, hearing rule violated. So you're looking at not in violation. So let's eliminate that. So all of them also goes for a toss. Non-renewal of a contract of employee of an employment of an employee after the period of contract is over. There's no problem here. The contract is over. So why should I renew it automatically? So this seems to be fine. C. Initiating a departmental inquiry against a public servant without giving an opportunity to submit representation of such an inquiry. Without giving an opportunity, hearing rule violated, ladies and gentlemen. So therefore that goes for a toss. So answer choice has to be B. There you go. Question number 85. On the basis of your understanding about natural justice in the passage above, state which of the following is true. Okay, what we understood with natural justice. Adherence to recent decision rule is not required if the other 2 rules are complied with. What is this? So there are other rules, H, R, B rule and R decision. This is not required if these 2 are complied. What is this? There is nothing of the passage that says that. Let's eliminate this. P. Compliance of bias rule itself rejects the need for hearing and the recent rule. So once this is done, there is no need for these 2 things. But who said all this? No, nobody said this. Principle of natural justice is incomplete without the compliance of any of his rules. That makes a lot of sense. So there are 3 rules. We should have focus on all the 3 rules, ladies and gentlemen. All the 3 rules should be a tick. So this makes a lot of sense. D says the recent decision rule is a substitute for the bias rule. Are they substitute? No, they are not. Answer choice is C. Now, when you looked at these type of passages, or when we started solving all these questions, what was important to us in the type 1 passage of rules is our ability to understand rules. If we can understand rules and what the rules are, and then this is a short, I'm going to call this doodling. This is a short doodling that I made here. Nothing much. I just basically, this can be either put in, I'm not asking you to write this down on a piece of paper. I'm not suggesting. You can commit this doodle in your memory and then answer these questions. So once you know these things, you know that all these 5 questions can be answered without any problem. And that, ladies and gentlemen, is a basic skill set that you need for type 1 passage. Now let's look at type 2 passage where there is an evaluation. What does evaluation mean? There is a rule somebody may have evaluated the rule. That's a good rule, that's a bad rule. That's a law, that's a good law, that's a bad law. There is an order, that's a good order, that's a bad order. You're making an evaluation on it. So the author is getting involved in this. In the previous case, in the passage is more in terms of expository passage, right? Expository is intending to explain something. The author is merely talking about principles of natural justice. There are 3 rules. That's it. But here is evaluation. For instance, if I take this case, alcohol should be banned because it is bad for health. Now you already evaluated whether alcohol should be banned or not. He's saying that it should be banned. And the reason is also given that because it is bad for health. Now if I were to ask you, what is a rule that this gentleman applied to arrive at this conclusion? What is the rule? So that's like if you think of this as an argument, I hope that you guys understand argument. Argument is something which has got a premise, which is a reason that is given to arrive at a particular conclusion, that you understand these things. I'm sure you know, because you're preparing for the CLAT, and critical reasoning is an important part of the CLAT, and you should know these things. So alcohol is bad for health. I'm going to call alcohol as A. Therefore, A should be banned. The rule or the principle, it's actually an assumption here. What is the assumption? Something is bad for health, therefore it should be banned. So the assumption is, in this case, or if I simply call the rule or the principle that has been used here to arrive at this conclusion is, if something is bad for health, if something, let's call it X, something, X is something, if X is bad for health, then X should be banned. That's a rule. Now if I accept this rule, so I'm not saying that I'm not asking you to evaluate whether good rule or bad rule. Obviously it sounds like a bad rule, a bad argument. But if you accept this rule and accept the rule, and let's say if I give us another situation, maybe let's say studying for CLAT is bad for health. And let's apply the same rule here. So what will you say? Oh, studying for CLAT should be banned, ladies and gentlemen. Yeah. So here what we used is that we are accepting the reasoning given by the author and forming that as a basis of our rule. In the previous situation, or the expository passage or the rules-based passage, the rules are very clearly laid out. And in these opinionated passages or evaluative passages, the author has a position, and that forms the basis of the rule. So let's look at this particular passage from the sample questions for UG CLAT. So when CLAT announced that they're going to change the pattern in last year, so around January 2020, they came out with a set of sample questions and subsequently sample papers as well. And one of the sample questions, or the first one, I think that is still available online. I'm sure that you get access to these things. You can just check. You can probably Google sample questions for UG CLAT, and you will get this file of the initial set of sample questions that they gave. And in that, the 2 passages that they gave had this particular format. Though I have not seen this in the CLAT 2020, barring probably one particular passage, the first one. But the majority of the questions are the rules-based sort of passage, but we should also know how to deal with this. Okay, let's give it a read. Last week, the government issued the Drug Policy Control Order 2013. Okay, that's a discussion. So we have got something that the government issues, a drug price control order, to increase the price ceiling of 21 medicines by as much as 50% to ensure the availability in the market. This is a welcome move. Already we know that the author has given his position. So this is saying that this is a welcome move. So author is saying good job. And now author is giving a reason as to why it's a welcome move. So that is the reason that is given. That's indicative word, ladies and gentlemen. So that's the reason because. And then author has given some justification. The lower prices would have further limited the availability of these drugs, some of which include those used in malaria, leprosy, and allergy. The decision by the regulatory authority, usually known to reduce the price of essential drugs, was prompted by repeated petitions by pharmaceutical industry, which pointed that the increasing cost of imports had made the production of some of these drugs unviable. Price of bulk drugs and active pharmaceutical ingredient have in fact gone up by 88% and largely imported. So we'll not bother too much about the reason that is given here. So these are a green signal. So basically what we'll focus on the fact that the author is saying that this is a welcome move. That increasing, increase the price ceiling of 21 medicines, that's a great thing. Right, that's it. So then we look at the next paragraph here. This raises a basic question. I told you in the last lesson, whenever you have a question, and that is going to be absolutely crucial. Should the government control prices? Now, this is like a larger question is asked here. Should the government even be controlling the prices? Here the government increased the price ceiling. But in the first place, should they even control the prices? So the whole discussion is about evaluating that particular statement, that should the government control drug prices? Should government control drug prices? That's it. That is what. Who should control the drug prices? That is the discussion. By the look of it, the author is going to say no. Okay. The motivation for controlling drug prices is not very difficult to understand. Unlike some of the developed countries where most of the population has insurance coverage or medical facilities are provided by the state, medical expenses in India are borne by citizens largely through out-of-pocket expenses. Therefore, the state intervenes by keeping prices of some drugs as a check to contain such spending. So basically, you look at this particular part here. This is important to understand what is going on here. This is the argument in favor of government controlling the drug price. Makes a lot of sense. So we are not a developing country. We are not a developed nation. We are a developing country. The citizens largely pay out of this thing. So controlling the drug price makes a lot of sense. But the most crucial word here, however, ladies and gentlemen, the author is getting involved. So there is a justification, yes, but the unintended consequence is that it affects the supply of drugs and can potentially make the citizen worse off. Now he's giving another reason, but there's a problem. There is an unintended consequence is that it affects the supply. Worse off. The risk of non-availability was an important reason for rising prices. Although all pharmaceutical companies may not stop producing drugs with price control, they may limit the supply. Further, the government usually deters on price hike because of political consideration, so it is not accused of favorable private companies. All these are here giving reasons. What is implied here is that the author has to giving a position. No, the government should not be controlling drug prices. This, however, is an indication that the author is implying it, and author is giving his reasons because there is going to affect the supply of drugs. There could be political consideration, a lot of this problem. And here again the word thus. That's what the author is saying. Thus, the government should stay away from dictating prices and allow market to function. The government should not be doing it. Market should decide. The market should decide price. That's it. In all this passage from here to here, what the most important thing to understand is understanding the author's argument. Argument has got a premise and other has got a conclusion. What we are interested is author's conclusion. Author is basically saying, look, the government should not be controlling it, the market should control it. And look at what his line of reasoning is. Competition in the marketplace will ensure that no company is able to make extraordinary profits in the basic and essential drugs. Since the state has limited resources, it should focus on regulation and ensure that the quality of drug supply in the market is not compromised at any point. So the reason why market should work, the reason that is given is competition. Okay, the competition if in the market ensures that it will automatically control the drug prices. Government, you don't be involved, you involve in regulations. So prices should be market, government should be involved in regulation. That's it. So the whole passage, if you actually look at it, is not just this part. Basically, market should control. Why? Because of competition. That is the line of reasoning. So this first particular paragraph is giving a background. That's it. The second particular paragraph raises a question and tries to answer the question. In the third paragraph, here author gives his position. That's it. Based on the author's argument in the passage above, this is what you see in these kind of questions, right? So the question says, based on the author's argument in the passage above, so we're going to say the author is right. What is the author's argument? Which of the following would be most correct? The state should not control price of medicine. That is great. That is no problem here. That is should not control. That is no problem. So let's look at whether the reasoning is fine. Since this would hamper the development of international pharmaceutical companies, what is this? What is this? This is not mentioned. The position is fine. The reasoning is wrong. Okay. The state should control the price of medicine. Gone. No, the state should not control. Okay, which means this makes sense. The state should not control the price of medicine. Good. Since the market would determine the best price for such drugs. This is C, right? And answer choice number D says state should control the price of medicine. Makes no sense. So basically this particular is what the author's argument is. The answer to this question, ladies and gentlemen, is very clearly C. Let's look at question number 2. Now there is a case, extra bit of fact given. And we have to apply to the fact on what? We have to apply to the fact, ladies and gentlemen, on the author's reasoning. So what is author's reasoning? Competition in the marketplace is important. Therefore, market should be allowed. That's it. An essential medicine formula A used to treat cancer, and there is only one company engaged in this manufacture. Wait a second, ladies and gentlemen. Let's look at fact. And one of the critical element of the author's reasoning is this thing called competition. And when you analyze this particular case here, based on that, one of the critical thing here is that there is only one company. If there is only one company, ladies and gentlemen, where is the competition? There is no competition. Therefore, author would, based on author's reasoning, since the competition is not there, therefore the government should be allowed. The state should not control the price of Formula A since it should allow the market to function. No, because it should not control because there is no competition here, because there is just only one company. The state should control the price of Formula A since there is no competition in the marketplace and it cannot control. So this makes a lot of sense. The author's argument is based on the fact that why it should market control, because market has competition. When there is no competition, then how can market control? So based on the author's reasoning, B would be the right as a choice, because the state should control the price since there is no competition in this particular case. The state should ban the sales of Formula A. Ban? What is this? What see? The state should take up the manufacture. What is all this? So I think the C and D has easy ditch me's. And I hope that some of you would have probably marked answer choice number A would have got it wrong. Please do understand the critical thing about author's reasoning. Author's reasoning is that what is the premise that is given to arrive at the conclusion that is made? The premise is competition in market, and therefore market should control price. Principle, competition is the one that can help control price. Here the competition itself is not there, so it cannot control price. Therefore market cannot control the price, thereby the state should control the price. Makes a lot of sense. So in these kind of questions, all that you had to do was to use the author's reasoning here as your rule to arrive at the answers. So per se there is no difference between the first type and the second type in the sense that I'm accepting and finding rules from the passage. It is just that the way in which rules are presented is slightly different when it comes to an evaluation passage, and the way in which rules are presented in the rules passage is different. That's it. In the rules passage, the rules are given to us. We accept the rule, we are trying to identify the rule. In this evaluation passage, what we are looking at is what is author's reasoning. And it's very easy to identify the evaluation passage because you see the author's opinion involved in the passage. So when you read the passage, you see author is putting his opinion, putting the evaluation, then you know that it's an evaluation passage and the author's reasoning is going to be important, and that's what gives me rules. Now let's look at the third type. Why is, for example, you might ask yourself, I've got a passage here, and I've got question 1, question 2, question 3, and so on and so forth. Usually what we find, fact here and rules there. Why should that be the case? Why can't I also give the rules here and also the facts there and ask you specific issues to answer the fact? That is pretty fine. There's no problem here. What if I only give facts and give different rules here? I can do all that. So usually what we find is that in the passage we don't see facts. Facts is in the question. But there could be a legal reasoning passage where the passage has got facts. And that, ladies and gentlemen, is a type 3. And this is from CLAT 2020's paper, questions 86 to 90. Let's read this one. Let's see what's going on here. Tension prevailed in the Jawahar area of Palghar district after 3 Mumbai residents travelling in a Ford EcoSport to Silvassa were allegedly lynched late on Thursday night. The Kasa police said the incident occurred near Gadakchinchale. I know that I have ruined that name. I'm really sorry, anyone from that part. Let's move on. occurred near some village under their jurisdiction. Information received by us indicates that the three occupants of the SUV hail from Kandivali in Mumbai and were going to attend a funeral in Silvassa. Oh, look at the irony. Superintendent of Police Gaurav Singh, Palghar Police said, a large mob of villagers surrounded the car within a matter of minutes and started attacking it with sticks, iron rods and their bare hands, leading to the death of all three occupants. What is going on, man? One of our patrolling vehicles later spotted the severely injured trio lying on the road and stopped to find out the matter. However, our team was also attacked by the mob and the vehicle pelted with the stones. So why would they attack the police? This doesn't make any sense. There is no justification now. Okay, they all not only attack and kill those guys, they also attack the police. Our personnel had to flee but unable to rescue the victim. Because they attacked the police, these people could not rescue and those three people also died. So not only you attack those three guys, then you attack the police who are trying to do their job as well. Villagers, what are you doing? What are you doing, my dear villagers? What is this? A wireless alert was sent out later, pricing all police station units of the incident, following which reinforcements were sent to the village and a combing operation was undertaken. Prima facie information indicated that the trio were mistaken for thieves and attack. So they basically, in fact, mistaken. Is it relevant? Just because can I attack anyone? The villagers were on the edge due to the ongoing lockdown, unavailability of essential supplies. So what? For the past few days, several rumors have been doing the rounds on social media about thieves and dacoits targeting villages on the highway. As a result, villagers have been patrolling the highway and stopping late night travelers on suspicion. That is also fine. So they're taking care of themselves fine. Actually, this particular passage here does not give us any principle. But I'm guessing that you and me as a reasonable person can make our own judgment on this particular issue as to what these villagers were doing. They were doing something that is absolutely wrong. This doesn't make any sense. On basis of rumors, you go kill someone and then you don't allow the police to do their job. Crazy, man. Let's look at the question. Which of the following statements given below justifies criminalization? So you're looking at something that justifies. This is very important. Look at the question. Now don't feel so let's look at this very objectively, ladies and gentlemen. Let's not feel too senti about this at this point in time. They'll be very objective. Criminalization of mob lynching, and that criminalization has to be justified. What does that mean? The mob lynching is a criminal activity. It's a crime. We're looking at some answer choice that tells us that mob lynching is a crime. That's our answer, ladies and gentlemen. Let's look at answer choice number A. In democracy, the actual power rests with the people and the action cannot be penalized. What do you mean cannot be penalized? We want to justify it's a crime. Answer choice A gone. There is no law in India which specifically prohibits mob lynching and therefore it is justified. What is this? You have to justify criminalization of mob lynching. We are not justifying mob lynching. We are justifying criminalizing it. It is impossible to punish the wrongdoer in the case. D, ladies and gentlemen. Violence cannot be a tool to implement the will of the majority, and such actions are failure of the state. So that justifies criminalization of mob lynching. That mob lynching has to be a crime. How can a mob decide to kill people? It's crazy, right? How can that's and whatever be there's no justification for this. Which of the following statement justifies the criminalization of mob lynching again? And now there we have got another parameter. So it's all looking at how do we understand the principle. I've given you the fact here. Now let me think about certain principle that I can apply to the fact. This question is kind of turned the thing around. Okay. In the earlier case, we are given principle and then given facts and asked to look at it. We have given facts and then we're asking us to think about a principle. What is the principle here? As a distinct offense apart from murder. So basically we are looking at something that says that mob lynching is something beyond murder. See, we want to look at something that mob lynching is something beyond murder. That is what you're looking at. Something that says it's not just murder, something that is beyond murder. Okay. The offense of murder is committed by a single individual or a group, but I like the but here. Mob lynching involves a large group of individuals. So murder is committed by a single group, but mob lynching is something more than that. Therefore, mob lynching is something that is apart from murder. A makes sense, but there's an all of the option choice, so we'll keep it on hold. Okay, it makes sense. While violence is committed by a mob, when violence is committed by a mob, it creates a situation of terror and anarchy, having potential to disturb the public peace of longer periods. So that is beyond murder. That makes sense. So both are fine, which means all of the both should be the answer, which means C also one makes sense. Mob lynching is an offense which supports the idea of might is right. It cannot be accepted in democratic society. Yes, that is something beyond murder. It goes beyond just killing someone. It actually impacts the society as a large. Society large. So we have answer choice D, ladies and gentlemen. The passage above states about the existence of rumors. So we got rumors. Okay, now this is getting into evaluating one particular fact, which is rumors in the area regarding the thieves and dacoits robbing the village and committing child lifting. Where is child lifting mentioned? Okay, this one's big. Okay. In the light of the proposition, which is the following statement correct? So it's just rumors. You can't take action based on rumor. Villagers should not be punished, as it was genuine mistake. But who is asking about mistake? Nobody is asking about evaluating the mistake. No, not the mistake. We are asked to evaluate rumors. Okay. First of all, this I will say chuck it. The villagers should be punished, as they do not have any right to punish any person unless he is an offender. So this, I think this particular first part is fine. You will agree. Villagers should not be should be punished, but the reason given has got a problem. Unless he is an offender. So if he is an offender, it's okay. The villagers should not be punished. But the reason say the villagers having a right to punish any person unless he is an offender makes no sense. The villagers should be punished. That makes sense. As no individual in the country is entitled to take law in their own hand and punish the wrongdoer. This makes sense. So this is more in terms of much more logically answering the question. The passage does not give us any sort of principle to go by with, but the CLAT authority has accepted that why should I give principle in this particular case? Why, as a logical human being, you can understand that what they did was wrong. If you can't answer this question, please don't come to my law school. Come on, I can't teach you these things. This is something that you should know. Okay, the villagers should not be punished as they have the right to private decision. What is this? This is law. Absolutely answer choice number C, ladies and gentlemen. Let's look at 89. In the light of the passage, which of the following mob violence would be justified? First of all, which the mob violence would be justified? I think that we should basically say no mob violence would be justified. What can justify mob violence? There is court of law. You guys are preparing for the CLAT to become a lawyer. If the mob violence can be justified, why are you there? Why should be there a system, a legal system in the country? On what case can you have mob violence is justified? What if, let's say, some other country came and attacked? Even then, what justifies violence? Nothing justifies mob violence. A group of people committing violence against the people who are selling meat or look, please don't. Okay, the residents of a boys' hostel caught a drug peddler selling drugs in their hostel and killed him. You're selling drugs. Don't kill him. Buy something from him. No, that's not what I'm saying. That's not what I'm saying, ladies and gentlemen. Don't kill him. Call the cops. The villagers injured a woman by pelting sound. Oh my God. I think that some of your heart will be boiling at this point in time. This is not something that you should take to heart. At the end of the day, you're solving these questions to get into the law school, right? But I'm sure that by reading answer choice number C, and you're going that who the hell will ever mark this answer? If there is one person who has marked answer choice number C, that even if let's say that person got 149 out of 150, that person should not be allowed to enter the law school. What do you say? They should have questions like this. Does he have them? For me to select someone, I'm going to have these kind of questions to check whether that's the same person to be the school. I'm just kidding. I'm kidding, ladies and gentlemen. I'm just kidding. Okay. I'm kidding. 90 assertion reason. Okay, let's look at this. Mob lynching can be justified. Far gone. No way. Only in circumstances where the religious sentiments or the assertion is wrong. So the assertion correct. Assertion correct, gone. Okay. Religious sentiments and feelings are of paramount consideration for the state should not be should not be interfered with. Paramount and should not be interfered with. What do you mean? Religious sentiments should not be interfered with. Incorrect, ladies and gentlemen. We will interfere with everything. Okay, there you have it. So what you'll have is this three type of passage, ladies and gentlemen. Rules passage, evaluation passage, facts passage. The fact passage, there are 2-3 versions of fact passage you can have. The earlier one that we just saw had only fact without any principle. There are also fact passages which could be there where principle and fact is also already given in the passage itself. So you are applying the principle onto the fact and merely answering the question. Yeah, it's also possible. But at the end of the day, the key skill set, whether it is rules passage, evaluation passage, fact passage, is to, and at least these two things for sure, which is going to be the majority of the type of questions, is your ability to understand rules when we read the passage. And what you learn today, you learn a lot of things. You learn that you are a good human being by getting all the questions correct in passage number 3. But apart from that, we also learn is legal reasoning is not so much about legal. It's not like you should know law to answer these questions. You don't need to know law. You should have good reasoning skills. Your ability to identify rules in the passage. That's a reasoning skill. Your ability to identify relevant facts in the passage. Reasoning skill. The ability to identify rules onto the facts. Whether it is legal reasoning or logical reasoning, whatever be the reasoning, ladies and gentlemen, this skill set is what you need to improve. Yeah. And ladies and gentlemen, in the next lesson, I'm going to talk about how to manage time in the legal reasoning section of the CLAT. I'll see you in the next lesson when I create it. Thank you and goodbye.